This is Michael Popok, Legal AF. Judge Chutkan already has her hands full with Donald Trump on one side and the special counsel on the other, and she doesn't need any other parties involved in the case. And we know that because she just issued a new order in which she's denied apparently about 8 different motions, which appear to be coordinated, for people who claim to be victims under the Crime Victims Relief Act of 2004, claiming that they were victims of Donald Trump's 4 crimes. And therefore, under the Crime Victims Relief Act, the CVRA, they're entitled, if they were truly victims, they're entitled to various things like to participate in the proceedings, to be there live, to be able to file papers in the case. And the judge got these at the last minute back in February, but we just know about them now because she's denied their participation, claiming that they are not victims. So we have a new ruling. Let me break it all down for you. First of all, we got Judge Chutkan back in her chair, back in the driver's seat, being placed there by the D.C. Court of Appeals and by the Supreme Court. She has regained jurisdiction in the case, as we like to say, and now she's busy kind of cleaning up the underbrush and getting ready for the August 16th hearing that she's going to be conducting about how to put the wheels back on this wagon and get this 4-count case against Donald Trump moving again in light of the immunity decision that she's now going to have to apply, issued by the Supreme Court in July. That's the Crime Victim Relief Act of 2004, which for those that are playing at home can be found at 18 U.S.C. 3771 of the federal statutes, basically gives rights to people who can legitimately claim to be victims directly or proximately who have been harmed by alleged federal offenses. Could be crimes or misdemeanors. This usually is embodied by physical, emotional, or financial harm. I presume, because we haven't seen the filings, because the judge wouldn't allow them to be filed, you have to make a request. That request is off docket, if you will. We didn't know about it until now. It was done in February. The reporting is there were about 8 of them, and they all claim to be victims. We're victims. I presume they're claiming that because Donald Trump tried to interfere with the election, he's charged with defrauding the United States, with obstructing an official proceeding, that they are voters, they are part of the electorate that almost have their vote denied because of the cling to power or have some other argument for victim status. But the judge is not buying into that. And let me just read you what she has written. She's written that leave to file denied. And there are 1, 2, 3, 4, 5, 6, 7, 8 orders, but they're all identical, meaning this was sort of a coordinated effort. It says, leave to file an amended application for CVRA relief. That's the Crime Victim Relief Act, dated 6/13/2024. There was one on 7/7/2024, 7/10/2024, 7/11/2024, 7/12/2024, and 7/19/2024. These are all motions to supplement a petition or motion for leaves on a petition. So we got those 8 filings. The court has said uniformly in response the following. Although courts have in rare instances exercised their discretion to permit third-party submissions in criminal cases, neither the federal rules or criminal procedure nor the local criminal rules contemplate that practice. Movement asserts a right to file on this docket under the CVRA, but they do not establish that they qualify as victim under the CVRA statutory definition. Back to what I said before. In order to be a victim, you've got to show physical, emotional, or financial harm directly or proximately caused by the crime, usually after the crime has been committed, convicted, and adjudged, not while it's still in progress, but we'll leave that aside for a minute. The judge goes on to say, consequently, the victim's rights enumerated in the CVRA do not attach, and the court is not persuaded that it is appropriate to depart from the ordinary course and permit this filing. Then she reminded everybody that the document is unavailable because the court has denied its filing, signed Tanya Chutkan. What does it all mean? The older I get, the more I find myself wanting to be more intentional about the way I live, eat, and take care of my body. MOSH, which you may have heard about on Shark Tank, was founded by Maria Shriver and her son Patrick Schwarzenegger. And they have a simple mission: to create a conversation about brain health through food, education, and research. MOSH joined forces with the world's top scientists and functional nutritionists to go beyond your average protein bar. With 10 delicious flavors, including 3 that are plant-based, each Mosh bar is made with ingredients that support brain health, like ashwagandha, lion's mane, collagen, and omega-3s. Mosh is now the first and only food brand boosted with cognizin, a premium nootropic that supplies the brain with a patented form of acetylcholine. Look, I can truly say Mosh bars taste heavenly, and I've been loving their banana bread bars. The energy boost these bad boys give me in the morning is unparalleled. With the fresh kick of energy and brain health supporting supplements in their fresh formulas, you can bet I'll be coming back to them. If you want to find ways to give back to others and fuel your body and your brain, Mosh bars are the perfect choice for you. Head to moshlife.com/legalaf to save 20% off plus free shipping on either the Bestsellers Trial Pack or the new Plant-Based Trial Pack. That's 20% off plus free shipping on either the Bestsellers or Plant-Based Trial Pack at moshlife.com/legalaf. Thank you, Mosh, for sponsoring this episode. It means that the judge runs a tight ship as we expected. She's got her hands full. She's got enough with the parties to the case. The people, the United States of America, represented by the special counsel on one side and Donald Trump on the other. She already has to take and map onto the indictment and make major decisions about liberty, about somebody's liberty, Donald Trump's liberty, about justice. She has to take the July 1st Trump versus United States immunity decision, which went primarily for Donald Trump in Donald Trump's favor, and decide which of any of the allegations of the indictment survive. She has to take a surgical scalpel and a lens, if you will, or a filter, and filter the entire indictment through these 3 levels. What's core presidential function? Because that's absolutely immune as of July 1st. What is official conduct of a president that's in the indictment, stretched to its outer boundaries and outer limits, because that is a presumption of immunity that can be overcome, but there's a presumption of immunity. And what is private conduct for which there is no immunity? She's got to run this screen, got to run this waterfall of the indictment through these screens and then see what's left. She has to take out and edit from the indictment any allegations that relate to official conduct, because they can't be used as evidence either, under the way that the 6-3 decision by the MAGA right came out. And then she's got to see what's left. I mean, is this a Swiss cheese indictment after she's done cutting and everything out? Is there anything left? There should be. Let me just give you my own analysis. There should be a living, breathing, viable indictment left from the original indictment after she does this hard work. Because Jack Smith knew that there was a possibility that the MAGA right could impose immunity. And so I think he drafted his very surgical, narrow indictment, not sprawling, for that purpose, to make it immunity proof, if you will. So, but she's going to have to find that. Then while she's there, she's got to figure out whether 2 of the 4 counts against Donald Trump, because there's only 4 counts in one defendant, Donald Trump, whether 2 of the 4 counts are going to survive for obstruction of official proceeding. And there, I think, again, my analysis again is that it should survive. Because even though there was a companion decision with the immunity decision that said that obstruction of an official proceeding doesn't really work for most Jan 6 defendants because they didn't get their hands and actually interfere with the counting of the Jan 6 certifications for electoral certifications, there is an exception if false evidence is used, false documents are used or fabricated, and that's the fake elector scheme, which is at the heart of the indictment. So I think she's going to end up at the end, and when she's done, with an indictment that survives, doesn't have to go back through a re-indictment process through the grand jury. This indictment survives mainly intact, the 4 counts mainly intact, and Donald Trump. What she doesn't need is a peanut gallery of others who are not really victims under the Crime Victim Relief Act. I mean, I'm all for real victims of crime participating in our public justice system and having a seat at the table, literally, just to be clear. And I'm not sure who these people are because they haven't outed themselves either. But it sounds like people who want to make mischief. And the judge doesn't need that. She's got enough on her plate. We have to trust Judge Chutkan's instincts, her demeanor, her power and authority and experience as a jurist to do the right thing. So I'm here reporting on her new order and also letting people know, let's not roil the waters over this. This is a relatively run-of-the-mill issue as she's getting rid of the underbrush, getting ready for the August 16th hearing. And we're going to see filings on the 9th of August that we'll cover right here on the MeidasTouch Network and on Legal AF. Because we sit at the intersection of law and politics. Follow us on Legal AF on Wednesdays and Saturdays at 8 p.m. Eastern Time on YouTube, on this MeidasTouch Network YouTube channel. Help us get to 3 million free subscribers. I thought we'd have to wait until Election Day. Ever since the Kamala surge and the Kamala Walls surge, I think we're going to get there by Labor Day. Help us free subscribe, get us to 3 million. We're building this network with you and your involvement. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.